Good morning, dear students. As promised, I will be recording my lecture for the fourth week, so you can listen to it anytime you are available. Okay, so our lecture or our topic for week four is about the law. No? So what is law? We have to go back to the basic question of what is law. Well, you have or you will find several definitions of what a law is, depending on whose perspective it is. In the Stanford Encyclopedia of Philosophy, for example, um, it calls a law or it defined a law as a complex social phenomenon and is one of the most intricate aspects of human culture. Now, in a book which I gave you, the Philosophia, authored by Bernardo and Bernardo, it defined law as something that connotes binding communal rules, the do's and don'ts of social order. So it likewise classifies law into jural or non-jural. So when we say jural, it is, in other words, human law. This refers to sanctioned or enacted laws such as statutes, case laws, normative rules, and precepts. So, meanwhile, non-jural or meta-legal are laws not anchored or premised on human promulgations such as divine law, the natural law, and physical law. So when we say divine law, it proceeds from the sacred writings such as the Bible or the Quran. It is sustained by religious faith. Natural law, on the other hand, is the law of the human nature, which will be discussed later on. Another is the physical law, which refers to the laws of the universe, such as the law on gravity and things like that. As lawyers and students of law, our main concern here is the jural law. Later, we shall also deal with this kind of law, which is, we will deal with this in details. However, when we want to point out the source of a right or duty, we look at the non-jural or the natural law. So, um, a Philippine case defines law in its specific and concrete sense as a rule of conduct, just, obligatory, formulated by a legitimate power for common observance and benefit. So this is the classical definition of law by Sanchez Roman that echoes Thomas Aquinas and several jurists. Aquinas, in his Summa Theologica, he explained that law is an ordinance of reason ordered towards the common good, promulgated by him who has charge of the community. So according to Aquinas, there are four elements of law as an ordinance of reason. First is that there must be a reasonable ordinance, or the rationis ordinatio. And the second is that for the common good or the bonus communis. And three, it must be promulgated. And four, it must be promulgated by legitimate authority. So if any of these elements is absent, there is no law to speak of, which must be observed. Now, the reasonable ordinance or rationis ordinatio, it means the ordering of reason. In simple terms, it refers to the way we organize our thoughts and reasoning to make sense of things. So this all about organizing our thoughts and reasoning processes so we can understand the world better and make informed decisions. Bonus communis or the common good, um, this refers to the idea of what benefits everyone in the community or society as a whole. It emphasizes actions and decisions that help improve the quality of life for all members of a community. So these include things like the clean air, good education, or public safety, or about looking at what is good for the group rather than just focusing on individual interests. For example, a community must or might decide to build a park that everyone can use rather than just improving one person's backyard. Bonus communis encourages people to think about their responsibilities to others. So it is about being aware that our actions can impact the community and um, also striving to make choices that contribute positively. So the other we already had two, right? We had the reasonable ordinance and then the concept of the common good or the bonus communis. Now, as for promulgation, we will have a separate discussion to of that later, so in details. Now, as for the fourth element, which is the legitimate authority, Aquinas believed that laws should come from legitimate authority, meaning those who have the right and responsibility to make laws for the common good. So this authority can come from rulers, governments, or other recognized institutions. Legitimate authority must be rooted in moral principles. So Aquinas likewise believes that if a law contradicts moral values or the common good, it loses its legitimacy. Those in authority have the responsibility to enact and promote law that serve the common good. So they must ensure that laws are just, equitable, and aligned with moral values. Now, in the case of Nilo versus Court of Appeals, so if you want to just check it, it's 128 SCRA 524. The Supreme Court defined law is a rule established to guide our actions with no binding effect until it is enacted. Thus, it has no application to past times but only to future time. So, um, this is why you seldom encounter laws that have um, retroactive effect, right? Except in criminal cases when the law itself or a particular special law itself um, merits what you call this retroactive effect, especially when such retroactivity would give advantage to the accused. No. So, Senator Arturo or former Senator Arturo Tolentino, a known civilist, described law in its general sense as an abstract science of moral rules founded on the rational nature of men, which governs his free activity for the realization of individual and social ends, of a nature both demandable and reciprocal. So laws that appeal to the conscience and moral sensibilities of ordinary men are morally obliging and will facilitate enforcement. Because if the constituents do not believe that such a law is morally right and would benefit the common good, the authority has or will have difficulty, facilitating the enforcement. So, does this mean that all ethical or reasonable norms must become laws? That's the question now. But the answer is that it does not follow. Only those rules concerning man in relation to his fellow men, those are the only reasonable or ethical norms that become laws or become a law. No? Law can only govern external moral conduct, not internal or private morality. However, there is a gray area on consensual acts between individuals. Now, going back to internal or private morality, so if you've observed, we don't have laws yet pertaining to or penalizing self-harm, no? Especially this very sensitive issue on suicide. So, can a person be liable for attempting to hurt himself? Is there a criminal law or a special law penalizing such? As of this moment, I have not encountered any. So, however, if you have read or if you're familiar with the K-pop or the Korean television or Korean showbiz entertainment, um, the authorities also, um, you, if you have read the news, no, the authorities also look for the reason behind suicide kasi medyo madami ng mga K-pop stars na nagpapakamatay sa kanila. So, maybe they're looking for the root cause such as bullying, no, or social pressure, and they're trying to legislate laws that would address the root cause. Now, as to consensual acts, there's a gray area pagdating sa bagay na yan. For example, why do laws prohibit child marriage? Kung nagkakasundo naman, everyone's agreeing to it, both the minors, the parents, both parties, and the people around, especially kapag it is part of their tradition, this part of their it has become their norm, diba? So now, as I already mentioned before, when we when we conduct lectures in barangays, in the municipalities, kasi bagong batas pa yung RA 11596 or the Act prohibiting child marriage, syempre may mga adverse reactions from our brothers and sisters belonging to the IP or indigenous peoples community as well as those practicing Islam because apparently they do practice child marriage. It has become their norm since time immemorial. Yun ang pinaglalaban nila palagi sa lecture na sinasabi nila, well, we have the NCIP law and we all know that the Philippine courts also respect no kung ano yung mga sarili nilang batas or how they manage the peace and order within their jurisdiction and among the members of such community. So bakit nyo kami pinapakialaman? If this is part of our norm, this is how we see, this is the best that that we believe is the best thing to do under certain situations, bakit nyo kami i-curtail sa aming right to practice our tradition and our um, uh, what we call this, our considered norm, no? And but then again, before this act prohibiting child marriage was enacted in 2021, several studies were conducted. So, in fact, the Philippines ranked as among the top 10 countries in the world with the highest number of incidents now involving child marriage. And they correlated it sa high incidents also of violence against women and children. Kasi, you know, nagiging cycle na lang siya or nakakos siya ng cycle of violence against women and children. Imagining or you imagine a minor, a girl, no, na hindi pa nga nakapag-enjoy ng kanyang kabataan, and then she's subjected to the responsibilities of having children or being married to an older person. So, syempre, hindi niya pa alam yung responsibilities niya, and she's not yet mature enough to handle the intricacies of marriage. So, nangyayari, nagkakaroon sila ng disagreements ng kanyang husband, nagkakaroon ng awayan, and nauuwi minsan sa violence, no? Patungkol sa mga kababaihan at kanilang mga anak. And it was observed na palagi na lang ganun. So, after a while, dahil hindi nga alam kung paano i-handle yung family, hindi pa umabot dun sa edad, no, na fully grown na yung physical attributes niya to handle family life, pwedeng magkaroon ng sakit, nagkukos ng postpartum na mga sakit, so namamatay, madaling natatapos yung buhay ng babae. And the legislative department, naisip nila, it's enough, tama na yon. So we have to do something. And this is that the enactment of the said law was one of their answers. Now, acts of incest, paano nga ba yon? Syempre, acts of incest, there is understanding, no? There is consensus. There is mutual understanding between siblings to live as husband and wife. So, kung hindi naman sila gumagawa ng any illegality to their own minds, wala namang illegal sa ginagawa nila kasi they're not hurting anyone naman. And also prostitution, if it's consented, uh, and also adultery, hindi na they're not the couple, um they're not happy, no, as a couple na, so they want to seek love and comfort from other partners, and both parties agreed to that, so bakit nga ba natin ipoprohibit? Now, the scholars believe that these issues may still be subjected to regulation in favor of family harmony and healthy procreation, which are considered public interests. So, kapag pumasok na yung public interest, especially, you know, sa incest, there are cases na kapag ang mag-asawa ay magkapatid or yung magkapatid actually nag-procreate, yung lumalabas na supling ay hindi healthy, no? So, lumalabas ngayon or nagkakaroon ngayon ng issue on public interest pertaining to health and peace and order, family harmony. So, sabi ng mga scholars, it can still be regulated even though consensual um, yung partnership or yung relationship ng mga parties. The public interest or the common good is based on the principle of equal dignity of all to have a quality of life. So it is realized through democratic participation or consideration of all members of society. It considers all stakeholders' interests, special conditions, and integral development. Now, let's go to promulgation of law. Um, well, maybe you have discussed this in your other subjects, such as the political law, but as a sort of reminder, you have to realize that promulgation is not equivalent to enactment of laws or how laws are passed, no? So, the passage of a law refers to the process by which a proposed bill goes through the legislative branch, like the House of Representatives and the Senate, and is then approved by the President. So, in the local government setting, the legislative branch in the local government units um, are the sanggunians or the respective sanggunians. And the the approving authority in the local government units is, of course, the chief or the local chief executive, such as the mayor or the governor. Now, um, so that's how the law or ordinance is being passed or enacted. Now, promulgation, on the other hand, is the formal announcement or publication of a law after it has been passed, so the public is officially informed. In the Philippines, laws are passed through a process involving both the legislative and the executive branches of the government. Maybe, yun na nga, um, na discuss nyo na to in your political law. So, to give you a detailed overview, this is how laws are being passed. First, there is a proposal. A bill is proposed by a member of either the House of Representatives or the Senate. And then, um, a bill can be about anything the government has the power to address, such as national security, health, or education. Now, it undergoes first reading. The bill is introduced in either the House of Representatives or the Senate. It is then assigned to a committee that reviews and discusses it. And then during committee review, it is being examined. The committee then will hold hearings and then suggestions may be given to make the bill a better law. So if the committee approves the bill, it moves to the next stage, which is the second reading. So the bill here is debated by all members of the House of Senate, and there can be changes to the bill, and every section now of such bill is being discussed. Now, in the third reading, after the debates and any revisions, the final version of the bill is now read and the members vote on it. So if the majority approves, the bill moves to the other chamber. For example, if the bill originally is from the House of Representatives, now the bill moves to the other chamber, which is the House, which is the Senate. No, so the process then is repeated. The bill must be passed by both the House of Representatives and the Senate, meaning there is a requirement for approval by both houses. So, of course, there are exceptions to this, no? But if the two chambers approve different versions, a bicameral conference committee is formed to resolve the differences. Now, once the chambers or both chambers agree on the final version of the bill, it is sent to the president for his action. The president can either sign the bill into law or veto the bill, meaning he can reject it or sasabihin niya hindi maganda itong bill na to, so hindi siya magiging magandang batas. But despite the veto power of the president, the Congress actually has the power to override the veto with a two-thirds votes. Okay. So the president may sign the bill into a law or veto it. And also, if the president does nothing for 30 days, no, hindi niya inapprove, hindi rin niya vinito yung bill, after the lapse of 30 days, the bill will become automatically a law, right? Due to the inaction. So once signed or passed without the president's signature, the law is published in the official gazette or a newspaper of general circulation to inform the public. Okay, so you had that already in your civil law, no, that there is a need for publication in the official gazette or in a newspaper of general circulation. An important aspect in the lawmaking process is notice to the public, either through a public consultation or through publication or posting in conspicuous places. Now, sa local government unit na setting class, we always recommend, because it is also provided in the local government code, no, that if the ordinance provides for penal provisions or mga pagbabawal, tsaka nag-i-impose ng mga penalties, the same must undergo um, public consultation, and then it must be published or posted in conspicuous places. So, pag sinabi natin conspicuous places, saan ba to? Siyempre, yung mga bulletin boards ng Kapitolyo, bulletin boards ng munisipyo, bulletin boards ng barangay, yon. So, yan yung mga examples. In the case of Tanyada versus Tovera, citing Article 2 of the Civil Code, the Supreme Court clarified that Philippine laws take effect 15 days after completion of their publication in the official gazette or in the newspaper of general circulation, unless otherwise provided. So after it is being decreed, it is the duty of every citizen to keep abreast of the law, and his ignorance will not excuse him from non-compliance. So, we have this maxim, the Latin maxim, no? Ignorantia legis non excusat. So, when you are not informed of the law, it doesn't mean that, or if you do not know the law, it doesn't mean that you are excused from compliance, or that you will not be held liable. So this legal maxim is a legal principle, no, holding that a person who is unaware of a law may not escape liability for violating that law merely by being unaware of its content. Because sabi na nga, the constituents or every citizen has the responsibility to keep abreast of each of the laws. Now, during the pre-Hispanic Philippines, as proved by the annotation of Dr. Jose Rizal on Morgas Sucesos de las Islas Filipinas, the laws enforced during that time were based on customary laws characterized by tradition, consistency, and harmony. So, hindi mo rin masabing ano na siya, isang batas na siya kasi ginagawa sa isang lugar. It must be proven to be a tradition consistently done, no, or practiced by the members of such community. So over long periods of time before mo siya masabing or makonsider na batas or norm in a certain community. So apparently the laws were not necessarily written on a piece of paper. So kaya seldom lang tayong nakakakita ng mga written laws ng mga kanuno-nunuan natin. So, malamang hindi rin yun na-post because during that time, baka hindi pa rin nila na-discover yung papel or sobrang mahal yung pagpaprocess ng mga papel. The laws are engraved in the memory of those for whom it is made. So, kunyari, yung mga batas tungkol sa pangangalakal. Okay? So, pinasa yan mula sa mga ninuno hanggang sa mga susunod na henerasyon. No? Pasalin-salin. Kunyari, yung mga batas sa pangingisda. Sinalin-salin din yan mula sa mga kanunuan na mga mangingisda hanggang dun sa susunod na mga henerasyon naman ng mga mangingisda. So, these were the laws, the norms and conduct taught to them by their ancestors, which they learned since their tender years and which were in harmony with the customs and traditions. Unlike these days, class, syempre, these days, meron tayong legislative department, no? Where the Congress or the respective sanggunian voted by the people, they are given the privilege and the duty to pass and promulgate laws, supposedly for the benefit of the common good. The law is enacted or disapproved through the yeas and nays during the particular session called for such purpose. Okay, so that's our discussion on the promulgation of the laws. Now, let's proceed with the concept of international law. Well, you might be familiar with the 2016 arbitral ruling pertaining to the claim of the Philippines in the West Philippine Sea. Right? So it has been a hot issue among the countries in Southeast Asia, and neighboring East Asian countries. Okay, marami tayong mga campaigns and propaganda na sinalihan, and then maraming nag-initiate ng mga non-government organizations, and marami ring mga mga groups na talagang they are actively participating, no, sa lahat ng mga activities patungkol sa claim natin sa West Philippine Sea. So, the 2016 arbitral ruling on the West Philippine Sea, so if you read the arbitral ruling, yung reference pa rin doon is the South China Sea, no? It's landmark decision by the Permanent Court of Arbitration in The Hague. So it involved a case brought by the Philippines against China's claims over much of the South China Sea. So there are key points discussed in the ruling, and among these key points are the following. First is this famous nine dash line of China, no? Because um, the Chinese government alleged na sa kanila yung area na yon because based on history, meron silang nine dash line. So, yung mga kanunuan daw nila nagsasabi na parte ng territory nila lahat ng bansa at lahat ng areas covered nung nine dash line na yon. But the tribunal ruled that China's claim to historical rights within the nine dash line has no legal basis under the United Nations Convention on the Law of the Sea or yung UNCLOS. It declared that China's expansive claims over the South China Sea violated international law. Now, the second key point is regarding the Philippine sovereign rights. The court affirmed that the Philippines has sovereign rights over its exclusive economic zone or the EEZ in the West Philippine Sea, particularly around the areas of the Scarborough Shoal and parts of the Spratly Islands. Now, the third key point is about environmental violations. China was found to have caused significant harm to marine ecosystems, especially through its construction of artificial islands and reefs, which damage coral reefs and endangered species. Okay. And also, the fourth key point of the arbitral ruling is that the tribunal found that the artificial islands which China built cannot generate new maritime entitlements, such as territorial seas or EECs, since these features were naturally low tide elevations or rocks before the construction. So, meaning no legal status for artificial islands. And another key point is China's interference. So the court found that China had unlawfully interfered with the Philippines' fishing and petroleum exploration activities in its own EEZ. But the question is the ruling really binding? Well, the law experts have several things to say. Syempre, some leaders believe that yes, the UNCLOS must be upheld, and likewise, the arbitral ruling must also be respected by the neighboring countries. But other the other side also argues that um, although there is an arbitral ruling, well, however, some leaders believe that we cannot bind China or even the United Nations cannot bind China no, with our ruling. It's because there is no law really binding between parties, even those members of the United Nations. So, China can actually deny or simply exclude itself from its previous ties with the United Nations or other countries with whom it has a conflict with. Now, however, one thing is for sure, the ruling or the arbitral ruling is significant in international law and maritime disputes, but it remains a point of tension in the region. So, class, international law is that branch of law that governs relationships between countries and other multinational actors such as agencies and organizations at the international level. Its purpose is for nation states to maintain peaceful and productive relationships among each other. International law relies on agreement or consensus from among its member states. So at present, there is neither a world constitution nor world legislature from which a binding world law could be enacted. So, sabi nga ng iba, okay, nandyan yung arbitral ruling, but how can we compel China to respect it, diba? Hindi naman yan batas. So, itong mga relationships na to, itong mga ties with the United Nations, these are just based on neutral agreements of parties. So, if a country sees that hindi na applicable or hindi na advantageous sa kanyang government or sa state mismo yung yung relationship niya or this agreement or contract that it entered into before, it can easily, you know, remove itself from such association. So, um, in fact, Article 38, Paragraph 1 of the Statute of the International Court of Justice, or the ICJ, enumerates what are now generally accepted as the sources of international law. So, international conventions or treaties, first, no, yan yung pinakauna. International conventions or treaties expressly recognized by the contesting states. Second, the general principles of law recognized by civilized nations, and also judicial decisions and teachings of the most highly qualified publicists of the various nations or juristic writings as subsidiary means for the determination of the rules of law. While Article 38, Paragraph 1 is silent regarding preference in case of conflict, some argue that the rules established by a treaty take priority in the determination of the international law. Others maintain that international conventions and customs have equal rank, that later treaties override older customs and new customs supersede old treaties. This is the reason why the Philippines or the chief executive, like the president in case of the Philippines, cannot just enter into a treaty with other countries without the authority from the Congress. Okay? Kasi etong mga treaties na to and international conventions, they bind the country, they bind the state, no? So, hindi naman basta-bastang pumapasok sa isang organization or sa isang agreement without considering first the pros and cons and the effect that it would have on the on the in the sa state natin. Now, gaya nga ng sinabi natin kanina, well, pwede namang umayaw or humindi after. But of course, may mga repercussions yan kapag eventually magkakaroon ka ng breach of contract, di ba? Pwedeng ipipressure ka ng mga members ng sinalihan mong grupo to do or that will affect your economy. No? So, kumbaga, as for us, hindi pwedeng sumali-sali ka and then later on, hindi mo rerespetuhin or um, magba-backtrack ka ng naging desisyon. No? So you have to, or the chief executive has to consider all the repercussions that it will have or it will cause. Now, um, huh? So, in any case, treaties and customs are generally regarded as primary sources, while judicial decisions and juristic writings of authorities in the field are subsidiary or secondary sources. But yun na nga, it is not clear whether the general principles of law recognized by civilized nations is primary or secondary sources. Now, if a law is a rule of conduct which a community considers as binding upon its members, then some argue that international law is not a true law for the following reasons. First, that there is no binding law that applies to all countries. Second, there is no World Congress legislating laws for mankind. Kasi nga, hindi naman makukonsider na law yung mga international law, di ba? Yung sources ng international law are merely based on the treaties and agreements and conventions of member states. Okay? So, there's no Congress to legislate. There's no World Congress. There is no world like chief executive of the world to approve the law so that everyone um, has no choice but to uphold it and to abide by it. So walang ganun in the real sense. The United Nations does not legislate, okay? It only articulates norms. For example, yung Universal Declaration of Human Rights, ba? It only encourages member countries to enter into conventions or treaties that binds the signatory countries. And if you join these conventions or you bind yourself or you bind the state no to these conventions or treaties, it is the responsibility of each member state to also uphold the principles tulad ng human rights. Kaya ngayon, member tayo ng United Nations at ina-uphold natin. In fact, parte siya ng ating constitution, no? Yung pagko-consider ng human rights, human dignity. So, international law as such consists of international treaties like what I've said earlier, which are voluntarily entered into by nations and customary international norms. The fourth argument of those who argue that international law is not a true law is that there is no world executive to enforce international law in case of violation. True enough, 'di ba? Yung Security Council or the United Nations Security Council, it may only mobilize armed forces in cases of number one, threats to peace. Second, breach of peace. And third, acts of aggression. Yun lang. Okay, that is written in Article 42 of the United Nations Charter. There's no such thing as international police to speak of. Walang international enforcement agency, no? So, a law, number four, is that a law is not a true law if parties are free to disregard it and if it cannot be enforced. Because sabi na nga, parang membership lang siya eh. If you don't like to be a member of such group, pwede ka namang umalis later. Alright? Now, Article 2, Paragraph 7 of otherwise known as the Non-Interference Clause of the United Charter, no, UN Charter, gives each member state of the United Nations the right to be intervened in not to be intervened in its domestic affairs. This is otherwise known as the non-intervention or the non-interference clause of the United Nations Charter. Now, if you remember, President Rodrigo Duterte before, galit na galit siya sa ibang mga member states ng United Nations, 'di ba? Especially hindi lang isang beses niyang or nagalit, hindi lang isang beses na nagalit siya sa United States and other European countries kasi nga nangingialam sa domestic affairs. So, ni-raise niya tong Article 2, Paragraph 7, referring to the non-interference clause of the United Nations. So, on the other hand, yung mga proponents who argue that international law is a true law, they contend that um, yung applicability to all countries is not actually a requirement for a rule to be considered a law. Okay? So, kung di naman ibig sabihin na hindi siya applicable sa isang bansa, hindi na siya makukonsider na law. Okay? Walang ganon. Another is that a World Congress and executive are not essential daw, no? Are not essential components in the definition of law. So, and third, international customary laws and treaties do have binding effects. A country that flagrantly violates its international obligations risks retaliatory action from the community of nations around the world. So, gaya ng nabanggit ko kanina, pwedeng may pressure, no, na i-impose sa isang country, economic pressure, or pagdating sa investment. So, hindi na papasok yung ibang countries na para mag-invest doon sa isang country na umayaw doon sa treaty or nagkaroon ng breach of contract doon sa treaty. So, yung may mga retaliatory actions such as that. Now, the basis of enforcement or obedience of member state is the principle of reciprocity. This means that nation obeys because it wants other nations to do the same, and it wants to be seen as law-abiding country by other nations. In practice, however, no sovereign state can be forced to obey international law without its consent or willingness to do so. This is because no international executive or world police force to execute international decisions, even those of International Court of Justice, an agency of the United Nations. So there is, however, an exception found in Chapter 7 of the United Nations Charter, which grants the Security Council coercive power with respect to threats to the peace, breaches of peace, and acts of aggression. Okay, so that is the concept of the international law, which will be discussed later in your higher years, so third year. You have this subject on private and public international law. Okay, so now let's proceed, no, do sa rule of law. So we usually hear the phrase the rule of law, but naintindihan nyo ba kung anong ibig sabihin ng rule of law? What does it really mean? Lagi nating naririnig yan that we are in a society governed by the rule of law. Ano bang ibig sabihin yan? In 2024, United Nations Secretary General Kofi Annan defined rule of law as a principle of governance in which all persons, institutions, and entities, public and private, including the state itself, are accountable to laws that are first publicly promulgated, second, equally enforced, Third, independently adjudicated. And fourth, consistent with international human rights norms and standards. So the rule of law also requires adherence to the legal principles such as supremacy of law, um, and accountability to the law, uh, supremacy of law. It means that the rule of law is higher than any person's discretion or will. Now, accountability to the law, this is that it means that one person is liable to be called on or to render an account before any law, no? And the third is fairness in the application of the law. Fourth, separation of powers. Fifth, participation in decision making. Six, legal certainty. Seven, avoidance of arbitrariness. And eight, procedural and legal transparency. So, a Harvard professor, Lon Fuller, in his Morality of Law, enumerated the 8 routes of failure for any legal system, and these are: first, the lack of definitive rules or laws, so that disputes have to be decided ad hoc. Number two, failure to publicize or make known to the affected party the rules. Kasi may batas nga, hindi naman nasusunod kasi hindi alam ng mga constituents or the target members of the society, the targeted members of the society. So, number three is unclear or obscure legislation. Number four, retroactive legislation. So see, yung retroactivity, hindi, it is being frowned upon unless it is advantageous to the person protected by the law. Number five, contradiction in the law, meaning several provisions contradict each other. Number six, demands that are beyond the power of affected parties to observe. Seven, unstable legislation or frequent changes in the law. And number eight, discrepancies between adjudication, administration, and legislation. So avoiding these pitfalls will ensure the internal or procedural morality of law so that there is reason in legal ordering. In layman's term, class, the rule of law simply means that everyone, including the government, must follow the law. For example, in the concept of equality, everyone is treated the same under the law, regardless of who they are. Whether you're a regular person or a powerful leader or the richest man in the Philippines, the same rules apply to you, ideally. Okay? As with the concept of fairness, laws should be clear and fair, meaning they shouldn't be vague or biased, and people should understand what is expected of them. As for accountability, it means that if someone breaks the law, they can be held responsible. This means that people and institutions can face consequences for their actions. Also, everyone should have the opportunity, no? Opportunity for legal help. Everyone should have an access to the courts if they need to resolve a dispute or if they feel their rights are violated. So the rule of law ensures that individual rights and freedoms are protected because laws should safeguard people's rights rather than restrict them. In short, class, the rule of law helps create a fair and orderly society where everyone knows the rules and has a chance to seek justice. Okay, so as a form of an exercise for this week, you have to cite an example or a situation that shows a poor or excellent legal system that you observed or experienced in the society. Okay, so I hope you learned something in this discussion, and
See you next week.